Welcome back to House General and Housing. We're taking testimony on S-125 relating to collective bargaining rights. And the last thing that happened was Representative Lamont asked essentially the question of whether either our witness wished to comment on what it was in particular about court managers that made it inappropriate for them or would compromise the court if they were to have a bargaining unit to bargain over things like working conditions, wages, and hours.
If I may, thank you, Mr. Chair. I was saying that the question really went to the heart of it because bargaining, once a unit is certified, relates to wages, hours, and working conditions. And the bargaining is supported by the right to file grievances, either on the basis of violation of the contract provisions or in many cases, past practices that haven't been negotiated away. And the inherent conflict that is being raised as a concern by the judiciary is that an employee in a position regarded as managerial would be sitting in discussions with the ultimate management of the judiciary as to whether the policy was good, bad, or indifferent, should be changed, should be retained, should be altered in some way. If that same individual was also a member of a bargaining unit that had filed a grievance against that policy or that practice, trying to advance the interest of the bargaining unit, the separate interest of the bargaining unit or its members, then a participant on both sides of the equation, if you will, is in a conflicting position. That's why there's no debate there's no attempt to eliminate managerial exemption, but there is under consideration the exemption of supervisors, which have been identified by the union as occupying what the judiciary considers to be managerial positions. And under those circumstances, the judiciary believes that they would be put into an impossible catch-22 position.
Thank
It
you.
wouldn't be a separate unit.
Are there
Okay.
any other
I
questions
guess
of Joe before we?
I'm good. I didn't ask the question.
Emily had a question.
Emily, did you have a question?
Yeah, I just want it's not for Joe specifically, but I just wanted to say one more thing as we continue to discuss this. You know, I in my time and experience working on these issues, you know, it is difficult for folks who are the employees. I will say too, as we talk about how hard it's been for the courts, it's also been hard for the employees and the working people that are in the court system as well. There's no doubt about that. As we move forward, I would like to, for me, it is to alter the bill and take this out would need some more discussion, and I would like to talk to the Senate and also remember that it is easy to hear from management on these issues many times, but it is more difficult to hear from people who may experience, you know, have experiences and want this, but they also may not. And so as we work on these issues, this is just allowing them the opportunity, which is in our jurisdiction, but it is not telling anyone to form a union or to do any of that. It is just there is a place in our jurisdiction where we can make those recommendations that they have the right to do that if that's what they choose. And I trust the labor relations boards to decide and discuss what management means. And but unfortunately, it's not always easy to hear testimony from the people who may want this. And so that's just something to keep in mind. That's where I'm
Thank
at.
you. Thank you, Joe, and thank you, Teresa. Our next witness is Chris Ford.
May I make a suggestion as well, which I'm happy to also reach out to Mr. Howard. He spoke yesterday or Wednesday about Vermont Labor Relations Board taking a very long period of time to address things and rather than having things in limbo. If there's something, a situation or concern that prompted this, I'd much rather learn about it and know about it and try to address it versus waiting and having
Well,
things.
I would not discourage you from talking to Mr. Howard.
Okay, exactly. That's to me would be a more straightforward way.
Well, it's certainly something that I encourage.
Okay, thank you.
So, Chris. Chris, I don't think you've been here, have you?
Yes.
Yeah. He has. You've been here.
Yes, we have permission to come out.
Probably not as much as I should.
That's good, right. All right. I do.
Granted, I wasn't sitting here yesterday.
Oh, you may not have been in the.
Maybe I wasn't in the room. Okay, doesn't matter. It's possible. I zone out sometimes.
Let's use that.
Okay, all right. Chris, would you state your name for the record again and take it away? And go ahead, please.
Good afternoon. My name's Christopher Hoare. I'll just say right off the bat that I wear a number of different hats. I'm the president of the Vermont Police Association. I'm also the state representative for the New England Police Benevolent Association. Two separate and distinct organizations. Some of those interests align, some of those interests are separate. So I'm happy to answer any questions on anything that, whether it's the proposed amendment that Game Warden Kelly Price talked about, or what I'm here to speak about today. Regarding what I'm here to speak about today is this bill as it relates to increasing the percent needed to file a decertification or certification petition to the Vermont Labor Relations Board. And I'll just start off by saying that the National Labor Relations Board, as well as the majority of New England and other states who allow collective bargaining, utilize the 30% standard in order to file a petition. We've already heard past testimony today on a number of things that I probably won't get into unless I'm asked questions on, just to not be redundant. But one similarity that I thought would resonate well with this committee is your election process. Your election process is very similar in certain ways. And I don't know if increasing the number of signatures, for example, you needed to obtain in order to run for the office that you hold was increased, it would inherently make doing so difficult. Whether that would cause someone to feel as though they couldn't accomplish or obtain what they're trying to do, or maybe cause them to think twice about it. One of the aspects as it relates to various unions, it is very often the incumbent that has the advantage as far as a petition for election concerned. We've heard about some of those, such as not being the person filing the petition is not allowed on employer property, oftentimes because there's a collective bargaining agreement, and it would be possibly the employer being seen as supporting an outside union. Another example was not being able to do it during work hours. Another example would be information readily available from the incumbent union. Again, as it stands now, there's already a number of burdens that need to be overcome in order for someone to file and then be successful in winning an election like that. One example that I would just throw out there is, let's say under the proposed changes, let's say there are 49% of a bargaining unit currently represented by another labor organization interested in changing their representation. And because it's always the case that, say, there's 10% who aren't interested, they're not going to vote, they're not going to sign a card, they're not going to participate in the election at all. The incumbent is going to win that election. They're not even going to be able to file a petition, even if that 49% is the majority. So one of the things I feel, or at least how it seems to me, is this bill is intended to establish certainty. And we've heard testimony in or even yesterday when we talked about, some people talked about rating, and that's employees moving from one union to another and vice versa. It happens. My union, for example, could benefit from this legislation, but it doesn't necessarily mean that we feel that this is good change for labor relations. One of the things that was discussed was employees' First Amendment rights. Unions face struggles all the time. The Supreme Court decision on Janus was a massive change to employee rights as it relates to bargaining. The basic premise of the Janus decision versus AFSCME was an employee cannot be required to pay union dues. So they have a choice whether or not they pay union dues or not. Similarly, I don't know why we would make it more difficult for employees to exercise their rights in deciding who represents them. We had testimony earlier today that said the size shouldn't matter as far as an employee deciding whether or not they want to be unionized or not. And I don't feel as though a majority is required to exercise their right to decide whether or not they want to or not. Again, it's the standard required to show interest. It's not the standard in order to make a decision. So it's just proposing an interest. People's opinions in feelings can change over the course of those months leading up to the election. And if you require a majority to just file a petition, then what are we saying about the election at all? Again, I think it seems to me that this bill is aimed at creating certainty and as close to as absolute certainty as possible without possibly raising any major issues. And I think certainty, I feel certainty is detrimental to unity, tolerance, and positive change. Because change can certainly foster all of those things. I've gone through the petition process just recently with the VLRB. I have been through the process of creating new bargaining units, representing old bargaining units. And it's a healthy process that's been established for decades in good faith. So, I've had bargaining units leave my union, and I think that's just the way that this process works. And I think it's a healthy process.
Thank you. Do we have questions? Yes.
In your experience, when somebody or when a bargaining unit is decertifying, are they more apt to decertify completely and no longer be a bargaining union, or is it because they want to be represented by somebody else?
That's a good question. I think, in my experience, I will say, I have never had the experience. I have read decisions on it, but, from the VLRB, but I have never experienced, a petition for certification filed and the bargaining unit deciding not to be represented by any union.
Decertification.
So I think,
He's asking in a petition for decertification. Is your experience that it is a bargaining unit just not wanting to be represented at all, or is your experience they want to be represented by somebody else?
in my experience, is because they want to be represented by somebody else.
I have a follow-up question. When that happens, and that had been my assumption, when that happens, is there normally an idea of who they want to, or is it just, we're done with you, we need a change, we don't, at this point, we don't care who it is? Or is there usually somebody that they're,
In order for someone to change, someone has to file a petition.
for a specific union?
Or to be represented by themselves and establish their own.
Okay,
A good example of that would be the Vermont Troopers Association. They are a union in and of themselves. They're not tied to a parent organization, if you will.
Tom?
Very high level question. Changing this percentage from 30 to 50, or 51 or whatever. Is this, who does this protect more? The union or the workers?
I think this proposed change is very much a protection of the union. Because even the employees that I represent, it would inherently be more difficult for them to even leave our union.
Any other questions? Thank you very much. Appreciate it. Sophie, could you come back up? I think the testimony today and the sort of logistics of the situation are such that we have a number of outstanding issues. One issue has been raised, which I think we can do some investigation on ourselves, is to find out a little more what happened in the Senate. And we can do that. That's not hard. Not that legally it makes the testimony received here any less valid. We've heard, I think there is a question raised by Emily, which is a good question. Is there testimony that we haven't heard, which we should? And we have the time to do that. Not a lot of time, but we have time. Another question that was raised is whether there are, what's asserted that there are differences between SELRA Section 18 and JELRA Section 10, 11, 13 on the definition of what is a management employee that are relevant for us to know and that could make a difference. The assertion is that there are, and that it could lead to needless litigation. I think that I, for one, at least would like to know what they are. I certainly and would love to see those sections myself, but also your thoughts on that. And that's why I asked, I mentioned this to Mr. O'Neill because he may wish to do that, but rather than have endless testimony, I thought it would be good for that to be done in writing. So are there questions? First of all, Sophie, did you hear anything in the testimony that's about the blackout periods or any of the other testimony that you feel as our alleged counsel that you want to comment on?
No, and again, I know we've gone off the record and come back on, so just Sophie Zadatni for the Office of Legislative Counsel. No, I think, it's just filling in the picture for all of you. I just hope it's becoming clearer and not more confusing. Because the goal, at least of going through the statute earlier, was I was hoping to provide clarity on how it works. I don't think the blackout period, I mean, I thought the testimony from Joe McNeil kind of explained that, we thought, effectively. I'm not sure it's really relevant per se to this question around, what should the threshold showing be in order to do an election over decertification of an existing union. So again, I don't know that the committee needs, to fully understand absolutely everything about labor relations to make this decision, but obviously more information and understanding the context, I think, is helpful. So I hope the committee's getting to that point where they feel comfortable of understanding what they're actually being asked for in this particular bill.
You think, I mean, this may not be a legal question that you feel you can answer, but I'm just curious. I mean, it seems as if, well, obviously, certification seemed to me logically that the blackout period, the 1-year blackout period after certification, where you can't file a decertification petition, I can see logically that comes from the idea that once you've gone through the certification, you need to give people time to negotiate a contract before you take them away. And also on decertification, I guess the theory is that you don't want to go through the disruption of a decertification petition and possible change in the middle of a contract. Is there anything you want to add to that?
The only thing I would add, which thank you for reminding me, is under the State Employee Labor Relations Act, it does cover, in addition to state employees, it does cover employees for higher education. So that 2-year limit is what is covered is for state employees. So in other words, University of Vermont, the Vermont State College System, they're not bound by that 2 years because, again, their funding is not, they don't need to have the appropriation from the General Assembly that the state employees and the and the judiciary employees would need.
So are they protected? Is the status quo protected for unions for UVM and state colleges during the time a contract is in place?
Yeah, and if you don't reach agreement when the contract expires, typically the status quo, you just continue with the current provisions. I've not gone through a decertification process, so I don't know how that plays out.
So you don't know, at this point, you don't know whether someone could file a decertification petition at a time that the contract at Vermont State Colleges is in effect.
I don't know that explicitly. I do know, typically, just from having looked at labor relations statutes nationally as well as in the state, that usually there is that window of, it's as you're getting towards the end of a contract. But again, there's, it doesn't have that same 2-year language, although I guess that under the rules it would apply. I mean, the rule I read to you around the 120 days, 150 days, even though the General Assembly is not a determining factor, those are the rules that apply under the State Employee Labor Relations Act. So one would argue that they would apply.
Are there other questions of Sophie?
Can I ask just one more question of the day, and other people can jump in? Start to finish, how long on average does it take to certify? And how long on average does it take to decertify?
I would say those would be questions for the VLRB. I mean,
Okay.
in the the section we looked through in the State Employee Labor Relations Act, they've got pretty tight timelines on when lists have to be exchanged and decisions need to be made. And so I mean, those deadlines can be extended, but the goal is to have it done expeditiously. So again, one of the reasons I think that the Vermont Labor Relations Board has struggled to address some of the grievances that are pending, and I know this committee and other committees have heard testimony around the length of time it can take to get a grievance resolved, is partly because, you know, there are strict timelines for something like this where you know, all hands on deck, you've got to get this done within the timeline. But yeah, so I couldn't say that may be something that the director of the VLRB could testify to.
I'm happy to do it.
Well, also, Steve, you've been sworn in, or excuse me, not sworn in, that, I'm so used to that. You've identified yourself. Do you have any thoughts on the question that was just asked? Is how long it takes on average to do a certification versus, and also a decertification? Do you have any particular knowledge that would help give that estimate?
Not sure I can answer the question on its certification. Decertification, it's relatively quick. I believe it's a couple of months, maybe.
Okay.
You would file during the open period. Generally, the election is over in a couple of months.
Because the list of who's included has already been determined. It's not like you have to go through that process that you do with certification.
Right. I mean, the certification process, in my experience, it's a 2-hour hearing at the Labor Relations Board. Union says they think these are the folks who we think are in the unit. Management usually comes in and says, no, none of those people should be in the unit. We argue about it and Labor Relations Board makes a decision.
Do you have to brief it? Their briefing and all
Usually,
that?
yeah.
Yeah.
Sometimes, I don't know about the recent history, but there is a mutual agreement during that 2-hour process.
Oh, excuse me.
And again, often the Labor Relations Board will work to try and mediate informally with the parties before they schedule a hearing to try to get those issues resolved. So they're only hearing about the handful of employees that the parties cannot agree on.
So just finally, it's my understanding then, and I'm that decertification, a petition for decertification doesn't lie during the time that a contract is in effect, minus that statutory sort of period at the end. You can start before it's over.
Right, you mean you
Right.
can see the end of the contract
You
coming?
see the end of the contract, a few months before it's over, you can start with decertification, right? Okay. Any other questions? Okay. Well, I would like to ask the committee, I feel the need to look at the statutory difference question. Is it okay with the committee if we find, if that information is provided to it? That's not. At this point, it's 3:00. Shall we spend some time discussing this statute? What's the committee's thought? We can, eventually, I'd like to say as chair, I do want to talk about each of the 3 issues in this contract separately. I'm not saying that necessarily that will lead to anything, but it might. People might, if there's, different views on different sections, so be it. I'd just like to know what they are. Do you feel today, people feel today like they like to say anything about any of the 3 sections on this?
I mean,
Yeah, cool.
no, you don't.
The decertification one, I'm not maybe wrap my head, I don't know, the understanding of why it's a different scenario, like I play it out in my head as it's the same exact company that's not unionized, they have 100 employees, and when 50, it's just 52 of them do a card check election, no voting, it's done. 4 years down the road, the identical 52 employees want to decertify, it's a different process.
Yeah, at that point, it used to be, as I understand, and Sophie, correct me if I'm wrong, it used to be before the card check amendment last year.
Used to be 30%.
30%, and then you would have an election. Now, if you can get the 50% plus to sign cards, there's no election, it's done.
I mean, you still have unit determination, you still have to make sure you've got the right.
Yeah, right, people.
Yeah, you're not doing an election.
Right. The reverse, then on decertification, if we were to go with this, it's the same 50%, but the result of that is it's not decertified, it's an election.
Right, it's, you're changing the higher threshold to trigger the election, so you're having a majority of the current unit members showing interest in wanting an election, and then you do an election, and if a majority want to change unions or not have a union, then that gets decided at the election.
Right, and the theory, I guess, being that if you, I mean, one might ask, I guess I'm discussing. And one might ask, well, if you have 50% plus to decertify, why bother having an election? I think the answer is because it could be, it's elections fought out, people debate, people can change their mind.
Yeah.
It's easy to sign a card, it's one thing, but it's another.
Think
Now,
of
you
the
could
argument
make
at the
the
beginning.
same thing, you could make the same argument with
Yeah.
card check,
You
but
got-
we did. There's no.
Actually, I think.
Actually, he did.
Yeah.
It is clear to me, at least, that the intention here is to make decertification more difficult. Period. Yes,
Just in that same vein, I agree that it should be similar. And also I would just say, because I was just looking at verification. And so it's 30%, but with the petition saying that there are 50% of the members who are employees who are doing it, but there's no verification that it's 50%. And I feel like by just making it 50% would be the verification that you would need. Because if you have people testifying in a petition that 50% want to decertify, but only 30% of the signatures are required, that feels a little wonky to me. And I appreciate the consistency of the 50%. It seems to make sense that if that's what you do to certify, that's what you do to decertify. And it also clarifies that you're not going based off of, well, someone's telling me that 50% of the people say they want to decertify. So I'm taking their word, and then we're gonna have 30%, and then we'll have an election. And it is just to an election. So the same difference is that it's like, to your point.
I think the board has to, in other words, if 50% of the people file a petition to decertify,
Right,
the board still, I think, the decertification can't occur until. the
no,
board
it's still an election. It's still an
No,
election.
it's an
though.
election, but even before the election, before the election is triggered,
Right,
the VLRB would have to go through those names and determine that they work there and.
well, but at least there's 50% of the names for them to
Yeah.
verify, is my
That's right.
point.
Yeah,
Like that is verifiable.
yeah.
As opposed to, you know what I mean, 30% of the names
Right, yeah.
claiming
Yeah,
50%, that's not
okay.
verifiable.
Well, I think that if on today's law as it is now, I don't know that it changes in the sense that 30% right now, if they file a petition, their names have to be checked by the VLRB. And what's confusing in the statute, it's so confusing, I suggest you forget it. It says that 30% of the people have to file a petition, which says in the petition that they
Yeah.
believe that 50%.
51%, that's what I'm
so
saying.
weird, I'd forget. It's just so weird. It's just,
Yeah.
I mean, it's weird. That doesn't mean it.
Yeah, that's it.
Yes.
I need some clarification on certification and card check. Is card check only for those who are not currently in a union?
That's for certification when there's no union present. For that, I mean, again, you could have a union in the workplace, but for that particular unit, an ununionized unit within a workplace.
And also a question, when you certify, and you use the 30%, so there's gonna be an election. Do a majority of the people, is it a majority of the people voting or a majority of the employees?
It's majority of the people voting.
If you decertify
Majority.
and there's an election, is it the majority of people voting?
Right.
Yes, okay, in either case, it's a majority of people voting,
Yeah.
like here. Except for propositions, yes. Go ahead.
I just. So, like Joe said, this is something that came up 2 years ago. This is something we did advocate for them to both mirror each other. I have a real issue with the language in this bill only being for salary. I think consistency, no, this is just for salary.
The decertification is solely for the State Employee Labor Relations Act. The judiciary supervisors is under.
Oh, that's right, yeah,
And I
not
think,
Joe.
and I think if we're saying we care about employees, I think we need to care about all employees regardless of where they fall. I personally think that consistency is clear and clear is kind and something we say a lot in HR, knowing where you stand, and I really take issue that it's.
So,
just for salary.
but if you had,
We would
if what you would
just
want is you
Selra.
would want to make it, because I remember Selra, Joe, if we wanted to be consistent, would we do all 7 or would we do? Some of them are, you said some of them
Some of them are odd.
are odd, yes.
So, yeah, I mean, when Act 117, where you brought in the majority, sign up,
Fair check.
check, I believe was done, I think it was for all 7. I don't remember exactly, or maybe it was 5. I don't remember. I'd have to go back and look and see which, but it was definitely not just Selra. It was other acts as well.
Actually, Emily, are you on? Your picture's up there. Emily, did you step away? You might. Do you happen to know, Sophie, why? This only applies to Selra?
That was what the sponsor requested.
But is there any logistical reason why it couldn't be applied more broadly?
I'd have to look and see what the
Did you
thresholds
do
are
that?
on the others. Yes, I will.
Thank you. Is that all right if I'm asking you to do that?
Sure, I mean, I, once again, preferably would like to see consistency through the entire process for all employees. And I mean that also regarding certification and decertification. But like I said, I am somebody who prefers consistency. I've talked to Sophie about, maybe we need to look at the definition of employees. I'm never actually going to request that because that would be absolutely ridiculous. But I think as we look at intent, I think if our intent is to be, put employees first, then it should be consistent for all employees. So I just wanted to know my concerns with this language and some of my issues.
Magali, when we talk about our potential week? By the way, our week, is that it?
Yeah.
Okay,
The only thing is,
doesn't,
Tuesdays, temperatures, thank you.
yeah, okay. Do we have any time for more of what? Yes, we have S-125, potential testimony on Wednesday, so we have time. Okay,
We have a walkthrough in Bartlett.
Yeah.
On Wednesday, and then currently I have committee discussion on Friday after the board.
okay. Does anyone have anything else at this time to say about 125? Yes,
I just want to remind people that the Senate had this bill for months. And so I'm sure that they did their due diligence and went through everything and passed it out for us to take a look at. I think we're getting more testimony and more testimony, and it's becoming more confusing and more confusing. You know, you never can say this is a simple bill because there's no such thing. But I would be happy to hear from the Senate. But I feel that you know, we need to come to a conclusion because it's almost May now, and it's going to get very busy on the floor. So that's just my opinion.
Yes.
I just want to respond. I think I absolutely agree, but there are two bodies for a reason. The Senate's taking testimony on our housing bill right now. We're taking testimony on theirs. We're going to make changes. They're going to make changes. That's just the process. And while I respect the work that the Senate has done, I'm not in the Senate. My constituents voted for me so I can be here and do my job in the House. And I have real concerns and issues with this entire bill. And I will be making those very clear. So I absolutely respect the work that the other body does, but we are two separate bodies for a reason.
Oh, and I understand that fully. I have been in this committee this is my 5th term. So I understand the process very well. I also understand how it works. And I think that we have, 40 some odd bills on the wall. Even judiciary has a dozen. I think we need to move along. I don't think we need to dwell. Yes, everyone has their own opinion, and I respect that fully. However, if we're going to make changes, then it has to go back to the Senate. Then we might as well forget about it until next year.
Happy to vote on this today.
Okay, let's do it. That'd be fine for me.
What I'm hearing is that there's a decision that I'm hearing that, first of all, I think it's important for us to hear what we need to hear. It's also important for us to get this out of here in a reasonable period of time, and I think that means probably next week. And I was going to ask the labor people who are here, and I will be asking the chair in the Senate committee whether there's anybody that they heard who we haven't, who we should. With the idea that if we dilly-dally about it very long, hearing people in order to get more testimony, if we do that for very long, we won't, then I agree with Mary, it won't happen. So I would ask of the labor people here that they let us know if there's anybody who testified in the Senate. You've mostly been here most of the time we've been debating. And if there's anyone we should have heard that we haven't, I'd like to know, but they have to be, and you don't have to tell us now, but they'd have to be important because we don't want to spend too much more time on this. I think that I'm probably going to ask for, before we have a formal vote, I'm going to ask for a little discussion on each of the 4 and each of the 3 pieces, and probably a straw poll on each of the 3 pieces. And the only reason I'm going to do that is that if it appears that there isn't, consensus at all, but we would have consensus on part of the bill, but not all of the bill, then we can deal with that. But otherwise, we've got to bring this to a close next week. Which means it's going to be a busy week because we have to bring 127 to a close as well. Other thoughts? And I have to say, I have been I was in one other committee where a member of the Senate was invited by the committee to testify, and then I was told that that is inappropriate. We're not supposed, just like we're not supposed to talk about the other body on the floor, we're not to have senators testifying here. But there's no problem with, regardless of that formality, I will find out how things went in the Senate. I mean, I think I've heard at least two members say, what happened there? I mean, largely because they feel like the Senate must have exhaustively heard this and came to this conclusion, and that should have some meaning. Subject to the fact that it's up to us to decide what we do. Any other comments, thoughts, or questions? All right, it looks like, just for your information, before you all go off to have a happy weekend, it looks like we are on Tuesday, we're not gonna have the tax increment financing stuff yet, right?
On Tuesday, we will not have the tax increment financing language.
But on Wednesday, we will,
Hopefully, hopefully.
right? So Tuesday, we're going to take up extreme temperatures, testimony on extreme temperatures. Sophie has a very rough draft, which she's unwilling to share with us. An exhaustive bill on extreme temperatures. The problem being that everybody else has dealt with it. All they talk about is heat, and we in Vermont care about cold. On Wednesday, we are going to spend considerable time, if they are ready, going through the tax increment financing part of the bill. And then on Wednesday afternoon, we've set aside discussion and walk through maybe testimony from on this bill on S-125. And then on Thursday, we'll come back to 127, and I am hoping we will be in a position before the end of the week to vote on it. We really have to get it out of here. 127, as I think I mentioned, but I'll repeat it as I did, has to go to Ways and Means and appropriation. Even if it had no appropriations in it, it has to go to appropriations because it once did have appropriations in it. If you would like to know why that rule is, don't talk to me.